Hi, my name is Nicholas Goddard. I'm an attorney here with the State Bar of Texas's Publications Division, and I'm here to talk to you today about the top 10 avoidable mistakes for mediations. While not as formal as a courtroom, mediations function much more smoothly when the parties involved conduct themselves in a professional manner. This involves making sure the client is aware of the cost of the mediation so that it is not a complete surprise after the mediation is over. This also involves preparing the client for possible scenarios based on how you believe, as the practitioner, that the mediation may go. Inform your client to avoid becoming too emotional and thus causing problems in the mediation for themselves and the opposing counsel and the mediator. If the mediation is going to be held remotely, make sure your client is set up to properly attend and that they know how to use whatever method of remote communication is being utilized. It's best to always ensure that the opposing counsel is aware of the mediation time and length. Do not surprise them with an all-day mediation when they were under the impression that they were only going to have a half-a-day mediation. Make sure the opposing counsel is aware of any of your client's issues beforehand so that they can consult with their client for a proper counter response or acceptance of any settlement offers. Furthermore, make sure that they are aware that the mediation is going to either be held in person or remotely. And do not send every piece of information you have to the opposing counsel the day of the mediation or right before the mediation begins. Mistake number 3 is failing to communicate with the mediator. Always, in a reasonable advance amount of time, send them any materials that you believe would best assist the mediator in helping mediate your case. It's always best to let the mediator know if your client is having emotional volatility issues beforehand, or if the mediation is being held by Zoom, that your client is having technology issues. Find out what the mediator's policies are so that you may inform your client of the rules and regulations within this particular mediation and that you both can abide by them fully. Always fully evaluate your case beforehand. That means understanding your case's risks and weaknesses as well as its strengths and rewards. Don't set your or your client's expectations too high in a mediation and avoid making unreasonable demands or hilariously low offers. Furthermore, avoid never compromising. This is an alternative dispute resolution, basically. Compromise is necessary to achieve that sort of goal. Don't railroad the mediator with your side and try to argue it like you are in a courtroom. Don't get upset or personal when the mediator goes against you. It's not personal. They're just doing their job. Every mediation, like every case, is different. So that means you gotta make sure that you have properly budgeted enough time for this particular mediation for this particular case. You don't want to find yourself still in the weeds of a mediation and having to end it abruptly just because you didn't properly schedule a hearing for another day. A mediation, just like with a court, should never be canceled last minute without a good reason. Always provide a reason in a reasonable amount of time ahead of time to the mediator and the opposing counsel and your client if you cannot make the mediation or if your client cannot make the mediation. Life happens, but don't wait to the last minute unless you have no other option but to do so. Mistake number 8 is failing to disclose any past history of violence between the parties. Not doing so could potentially hamper the mediation and cause serious problems for your clients. In a courtroom, it may make sense to make a long-shot argument on behalf of your client. In a mediation, it does not. Your time is limited, the mediator's time is limited, the opposing counsel and both clients' time is limited. Especially in a mediation, they're just trying to get this done as cheaply and quickly as possible. Don't waste time or money with unwarranted arguments that serve no real place in the mediation. And the 10th and final avoidable mistake for mediations is scheduling a mediation without consulting the opposing side. There are many a time where you'll come across a case that you believe could be quickly and efficiently settled through mediation. And so you go and schedule that mediation with your favorite mediator, only to find out that the opposing counsel cannot make that date. So now you are left with having to reschedule this, a potentially angry opposing counsel, a potential angry mediator, and potential cost incurred for your client for rescheduling. It's always best, well in advance, to consult with the opposing side about setting up a mediation. Courts encourage mediations before going to trial in a lot of cases. And the best way to do this is to have the opposing side on board from the beginning. Again, my name is Nicholas Goddard. I'm an attorney with the State Bar of Texas Publication Division. For more tips, go to texasbarpractice.com.